Hello and very good evening, everyone. Hope you all are staying safe and healthy. I'm Achal Dua, Senior Consultant with EBC Learning. On behalf of EBC Learning, I welcome you all to this session on specific performance, no longer an exceptional or discretionary remedy. We at EBC Learning are focused on helping you not only to excel in law school, but also to equip you in practice study skills. And this webinar is part of our series of webinars, which we have been organizing very frequently. And today we have with us Dr. Nilima Bhadbade. A very warm welcome to you, Professor Nilima, to EBC Learning. It's our privilege to have you here with us. Now, let me introduce our guest speaker to you all. Dr. Nilima likes teaching, and after a decade of civil trial and appeal practice, she joined ILS Law College, Pune, where she taught law of contract, evidence, property, and insurance. There, she also developed extensively advocacy skills and activities for students. She writes at obitadicta.in, where you can find her lectures and training programs on contract and practices law. She also has revised 3 editions of Bullock and Mola's Indian Contract and Specific Relief Acts. And if you wish to read more of Professor Nilima's articles and chapters in books, you can visit her LinkedIn profile. Last but not the least, her research about the remedy of specific performance led to a book, Specific Enforcement of Contract Terms. I'm sure this is just a glance of the vast legal work Professor Nilima has already done. It's an honor to have you here with us, Dr. Nilima. Welcome again. And also, I would like to inform all the participants here that there will be a Q&A round at the end of each of the session. And we have tried to keep it more interactive and more informal for you all. You can write your questions in the chat box, or also you can raise your hands, unmute yourself, and you can directly put your questions across to our speaker. Now let's get started and learn more about the specific relief by India's finest experts, Nilima Bhadbade. Dr. Nilima Bhadbade. Without any further delay, I would like our speaker to take it forward from here. Over to you, Professor Nilima. Thank you. EBC platform is all yours now. Thank you.
A very good afternoon and namaste to all of you. And a special thanks to Mr. Abhinandan Malik, who is the director of EBC Publishing, and Dr. Anchal Dua, who is going to moderate this session. She's a senior consultant at EBC Learning, and it will be wonderful to join you all in this session. I especially enjoy talking about specific performance simply because while doing research, I enjoyed studying the subject. And whatever I know or whatever I read, I will be able to share with you. My presentation today is less about case law, but it is more about principles applicable to specific performance. My session today is in 3 parts. In the first part, which is a bit longish one, I will discuss specific performance, which is now a general remedy. And even as a general remedy, it is available only if it can be effectively enforced. In the second part, I speak about discretion in grant of specific performance, which the amendment has done away with. And lastly, I will speak about the new remedy of substituted performance, which probably will not require many plaintiffs to ask for specific performance because this remedy is available. The occasion of today's session is the amendment to the Specific Relief Act, which came in 2018, because of which specific performance is no longer exceptional and it is no longer discretionary. We have to see how the law develops. I will also introduce in the beginning itself that the entire report of the expert committee, after which the act was amended, the entire report was not accepted. It's only partially accepted. And so what are the gaps which remain? I will be speaking about them also today. Now, our subject today is about remedies for breach of contract. If a party has broken a contract, then he can seek many reliefs. He can, of course, seek return of amount. We are not on that aspect. But what are the reliefs which we, as we put in inverted commas, say that they put the plaintiff into a position as if the contract is performed. And these two reliefs or remedies are specific performance and compensation. Now, whether it is the one or the other that is sought, there are actually two phases in what the plaintiff asks. In the first part, he has to basically show that there is a contract, that some term of the contract is broken. So he will have to highlight which is that term, which is the provision of the contract that is broken. And then he will have to show that the defendant has committed an act which amounts to breach. Because we all know that some acts of the defendant may appear to be breach, but they may be excused. So the fact that it amounts to breach. And this part is common whether the plaintiff asks for specific performance or for compensation. I'm using loosely words because in specific performance, we talk about refusing to perform. And in the case of breach, we say that the contract has been broken. But I will use these words interchangeably for today's purposes. Now, once he says that there is a breach, then he will ask for what he wants because of that breach. Like I said, there are many more remedies, but he may either substitute what he wants. So instead of saying, give me what is promised, give me the land under the agreement to sell, give me the goods that have been promised to me. So instead of saying that, he says, give me a substitute, compensate my loss. And therefore, compensation is often referred as the substitutional remedy. But it is the main remedy which the law also would want the plaintiff to ask for many reasons. And one of the reasons is that once the amount is fixed by the court in the form of a decree, it becomes easy to enforce it by taking hold of the properties of the person and recovering it from those properties, assuming there are certain properties left. So my point is that substitutional remedy is encouraged of compensation, and it is encouraged almost across all jurisdictions in the world. Specific performance remains exceptional, but it should be available. This is the position we are going to see today. The other relief is asking the court to order the defendant to do exactly what he has agreed, and that is specific performance. So my point is that there are two phases. The first part is relating to contract law, and the second part is relating to relief. For compensation, it is the contract law. And for specific performance, it is the Specific Relief Act. Now, the first phase I discussed is establish breach, and I have done point number 1. I come to the second point, that in this first part where he establishes breach, the defendant may have many defenses, and these defenses may deal with whether the contract has been formed or not at all, whether it is valid or not, or is it void, whether the non-performance of the plaintiff has given him an excuse not to perform, and so on. So it could be mistake, uncertainty, illegality, material alteration, failure of consideration, impossibility, remission by the promisee, novation, alteration, plaintiff's failure or non-performance, a valid rescission by the defendant, and so on. Whatever defenses are available in contract law are all available under the Specific Relief Act in a suit for specific performance. And this is what Section 9 of the Specific Relief Act specifically says. So this first phase is over. And let us suppose that the court has come to the conclusion that yes, the plaintiff is entitled to relief. So we therefore have these remedies. There is a distinction between reliefs and remedies. Basically, remedy is that which the court will grant to the plaintiff. So there are two remedies. The first is compensation, and the criteria for deciding how much and which losses will be paid. I'm sorry, it should be the reverse. Which losses will be paid and how much for each item are given in Section 73 of the Indian Contract Act. The how much is to be proved by the plaintiff, but which losses is governed by this rule in Hadley versus Baxendale. Those which naturally arise and those which were in contemplation of parties when they made the contract. So basically, three principles that will apply to compensation. Number one is, of course, that the loss is caused by the breach. This is causation. Second is referred to as foreseeability. Our law uses the word contemplation. So was it in contemplation of the parties when they made the contract? And the last is that the plaintiff must mitigate. So he must try to take action to reduce the effect of that breach, try to reduce the losses. And based on this, the compensation will be awarded. Therefore, even if a plaintiff has suffered a loss, let us say of 20 lakh rupees, and that is what he has calculated, it is likely that applying these principles, the court may not award the whole. And that is the problem with asking for compensation. This is compounded by the fact that the plaintiff may not be able to prove all his losses and he may not be able to prove the amount which he has lost. We will, of course, forget the interest rates and the loss he suffers because he's kept out of the money and out of the contract. Therefore, any award of compensation, it is said, it undercompensates a plaintiff. And the relief of specific performance enables the plaintiff to get exactly what he wanted. So the second remedy, which is the primary remedy, as they say, which is not substitutional, is specific performance for compelling the defendant to do what he has promised to do, and injunction to restrain a defendant from doing something which he has agreed he will not do. So these two are or have been governed by 4 requirements or 4 hurdles. I like to call them hurdles because as a plaintiff, one is required to cross each hurdle until the plaintiff gets that remedy. So I refer to the 4 of them under the Specific Relief Act before 2018. The first is the test of inadequacy. It's also called the adequacy test by some writers, but basically under Section 10, this is what makes specific performance an exceptional remedy. The second is the test of Section 14, that yes, the court should be in a position to completely enforce the contract. The third is the plaintiff's own conduct, which usually is not relevant in a suit for compensation, that he should be ready and willing. And the last is circumstances affecting discretion. The fact that the remedy is discretionary, and the court may not grant it simply because it is lawful to do so. So after a plaintiff crossed all these hurdles, the last one is, of course, with the court, then only he will be entitled to get specific performance. Now, of these, the amendment of 2018 has done away with the first one, Section 10. It has changed Section 14, and we will see what is the change and what is its effect. That will be the first part. The second part, the plaintiff's own conduct, I will not refer to. There is a simple amendment which I will mention straight away. Before the amendment, the plaintiff was required to aver and prove. Means his plaint must contain these words, ready and willing, that is aver. And prove means he must actually show the readiness and the willingness, or anything contrary to that. If it is seen that he is unwilling or he is not ready, he will not get specific performance. After the amendment, the word aver has been removed. So it is all right if he has not used the words ready and willing, but the word prove is still there. And therefore, just if the plaintiff misses using these 2 words in the plaint, that will not hamper his remedy. So this is the amendment, and I will not be coming back to it again. And the next part is, of course, discretion. Now, I have divided it in 3 parts, as I said, and at the end of each part, I will request if anyone has any questions, and I will try to answer them. Time permitting, we can also have questions and answers at the end of the session. So now let us look at specific performance as a remedy. There are actually 2 parts of specific performance, or 2 aspects. One is that the plaintiff must get done what he wants done under the contract. So if it's delivery of goods, he must get the delivery of goods. If it is land which is agreed to be purchased, he must get that land. So his getting it is the one part. And the second part is who should perform it? The defendant. So the defendant must perform that which is agreed under the contract. That is the second aspect of it. Now, our law deals with the second aspect. That is, that the order must compel the promisor to perform. And therefore, specific performance is directed against the defendant who is going to perform. There are, of course, other people under Section 19 against whom the relief can be asked. But basically, the important thing is they are all connected with the contract, or they are connected with the party to the contract, or they claim through the party of the contract. And that is why an order can be passed against them that they should perform. And therefore, whether it's to transfer property, deliver goods, construct building, or not join a competitor, the order directs against the defendant, that is one of the party to the contract. And the court orders the promisor to perform. So that is how the decree will be given. Compare it with the first situation which I discussed. What is it? What is important is that the promisee gets the performance. Who does it may not matter. And this is what now the amendment enables by providing the remedy of substituted performance in the new section 20 of the Act. So if one opts for that, then what is important is that the promisee gets the work done and then can recover. How this is different from the current law, we will see that later. Now, this specific performance is of exceptional nature because of what we call the threshold test of inadequacy given in Section 10. Inadequacy is the word I have been using in my research. Like I said, it's also called the adequacy test. Now, this inadequacy means what? Inadequacy means that any amount of compensation will not be adequate. Compensation is not enough. And Section 10 uses two circumstances. One is where compensation cannot be ascertained, so it is difficult to prove the loss at all. For example, the subject matter is unique or it is of special value to the plaintiff. So let me take a very simple example. Let us imagine that X has agreed to sell me an old shirt. The value of the shirt today is probably nothing, or maybe 20 rupees or 30 rupees. But he's promised to sell it to me for, say, 20,000 rupees. I am wanting that shirt because that shirt belongs to a certain well-known personality. Now, this shirt, therefore, is unique. You do not find this anywhere else, and it is unique because of this quality as to who has used it. There is the value which goes over and above the actual value of that article. I continue with the same example. I am willing to pay him 20,000 rupees because it is my great-grandfather's shirt. So here, the value of the shirt, even though the actual value may be only 20 or 30 rupees, it has a special value to me because it was used by my grandfather. In both these circumstances, it's 20,000 or 50 or 1 lakh. You can never calculate what will be the actual loss if the person does not give that shirt. And this is the idea of the first part, that is where compensation cannot be ascertained. The second part is, okay, you can ascertain it, but it will never be adequate because it is difficult to get substitute performance. For example, there is an article which is being sold. These are criteria from Section 10, but they tell us volumes about the nature of subject matter which ought to exist in order that specific performance can be had. It is not an ordinary article of commerce, so it's not available. There are only few suppliers. Even they are fully booked. So that in that case, compensation is inadequate. The second is it's not easily available in the market. For example, it is required to be got done, or a person has agreed to sell entire produce of that factory. Then it's not available in the market. So When this is the case, although loss can be calculated because the value of the goods, the profits, etc., compensation can be calculated, but that is not enough because there are other factors which, the delay which will be caused because of these not being available, and they will probably not be available at all at the time at which the plaintiff wants. That is why compensation becomes inadequate. So, this is what this section 10 made specific performance exceptional. And this is how the section pre-amendment looked. A longish one. First of all, it said that contract may be enforced. And then the word discretion, where there is no standard for ascertaining actual damage or where compensation would not afford adequate relief. And then there were two presumptions, one relating to immovable property and the other relating to movables, that if there is a contract to transfer immovable property, then it was a presumption that compensation will be inadequate. And if the contract was to transfer movables, then if this is shown, these three items are shown, then only compensation will be considered inadequate. So if I am a plaintiff and I file a suit for enforcing an agreement to transfer immovable property, the chances of my getting specific performance are high because of the presumption. But if I am seeking specific performance for contract to transfer movables like goods, then I will have to show further factors, which are these factors. I will bring to your attention that I am the victim of the breach, and yet I have to show all these things. I will come to this aspect later. So we ask, why was this exceptional? This is a feature of most common law countries. Many other countries, like civil law countries, they provide specific performance as a primary, some say it's the main remedy, but basically it is available to anyone who asks for it. So the exceptional nature comes from history, English history. And that is because of the separation of the common law and equity courts long, long ago. That is in the 13th century. Later on, in 1872 or so, both the courts, common law and equity courts, were unified, were merged. However, the difference in the remedies still remained. When our Specific Relief Act, the first one was made in 1877, and later on in 1963, it was thought desirable to retain the equitable nature of these remedies, and that is how they retain the equitable nature. The second reason why it should be exceptional is because it is stated. Now, what I have gathered, these are observations in judgments, and these are observations in academic writings. The remedy for contempt is too drastic. The way specific performance will be enforced if a person does not obey is by threatening him with contempt of court. And we all know that a court should not use this weapon too often. And therefore, it is considered to be very drastic when it is applied. So that is one reason why specific performance is exceptional. Let the occasion to use contempt be as few as possible. The third is, of course, an expectation that the system must protect personal liberty. The personal liberty of wanting or not wanting to, for example, do certain things. The next one is that we must learn to balance the interests of parties and the costs of administration of justice. When it's just compensation, then it is a matter of collecting the property and recovering the amount. But when it is specific performance, more participation from the court becomes necessary, especially if it is a constant sort of promise which requires supervision. So the court has to supervise into how the decree is to be made, then whether the decree will get effectively done or not. And it costs more. This is what economic analysis of contract done by many authors, they all project that it is more costly to enforce specific performance than it is to enforce compensation. And the last is practicality of enforcement, that sometimes some types of promises, you just can't execute them effectively. And I will come back to this aspect. Therefore, let compensation be the rule. And until it is so exceptional that, compensation will not be enough, then only ask for specific performance. So this is the background. Now, when the remedy is exceptional, this will be the procedure. If I am a plaintiff, I have to identify my contract. I have to categorize it into whether it's movable or immovable. And the manner in which today's contracts are made, many of them are for services. They are neither goods, so they are neither movable property, transfer movable property, nor are they contracts to transfer immovable property. So we have to categorize them. And then we have to establish, or the plaintiff has to establish, inadequacy. So the plaintiff has to show that this is not available. At least he has to allege in the plaint. Of course, if it's immovable property, the presumption assists him. He need not state anything. The point is that the burden of proving entitlement to the remedy falls on the plaintiff. The plaintiff is the victim of the breach. And the defendant is then allowed to constantly say, no, you are not entitled to the remedy. Yes, I made a contract with you, but you are not entitled to the remedy. So the new amendment, we suppose, will change this situation of burden of proof. Now, because of the inadequacy test, therefore, the plaintiff cannot choose this remedy. I mean, no lawyer will advise a plaintiff to go for specific performance other than contracts of immovable property. During my research, most of the judgments where I studied inadequacy, most of them were immovable property. Reason being that if it were not immovable property, perhaps the lawyer did not advise his client to claim specific performance at all. The burden then lies on the victim and not on the breaker, and obtaining the remedy is uncertain. So even in the case of immovable property, one never knows whether one will get specific performance in the end or not. Was the test relevant? So again, during my research, I took out almost all judgments available on All India Reporter, SCC, and Manupatra, which were on law of contracts, and which were about contracts, and which were about specific performance, permanent injunction, or temporary injunction. Because in all these cases, inadequacy or loss being of irreparable nature is a criteria for grant of the remedy. So I also considered judgments which were about factors of giving temporary injunctions in matters relating to contract. And in most of the judgments, decisions were based on other factors and not inadequacy. So it could be discretion. Then the judge says, yes, inadequacy we will not deal with. In the exercise of discretion, we will not grant the remedy. So very few judgments actually dealt with the inadequacy test. Wherever they dealt with the inadequacy test, it was decided merely by inference. I mean, how does one say that compensation will be unascertainable or inadequate? Most judgments do not give any discussion. The judge simply says compensation is inadequate or compensation is adequate and therefore relief is not granted. Very often it depended on the perception of the judge. There are judgments of the Allahabad High Court relating to sale of fly ash, which is a byproduct in a thermal power plant. And one judgment says that fly ash is of course goods and therefore no specific performance. Another judgment says fly ash is not easily available because it's always available only in thermal plants and therefore specific performance. Rather, they were about injunctions, so injunctions can be granted. So one judge looked at it in one way and another judge looked at it in another way. They gave, of course, their reasons, but ultimately it depends on the perception of the judge. And as I said, many judgments do not give any reasons why they consider in that particular case that specific performance ought to be granted. These are, of course, the very few cases which are not relating to immovable property. Now, civil law systems make available specific performance as a general remedy. France, Germany, Switzerland, most of Canada, 3 states in the US which follow the civil law system. Most countries which were ruled by the British have the common law system, and most of USA, where specific performance is exceptional. Now, wherever specific performance is available as a general remedy, there are still factors based on which specific performance may not be granted. They may either be in the exercise of discretion, or they are factors which the court has to consider anyway, so they become matter of proof. Then so many conventions like the CISG, it favors specific performance. It has a provision where it may be difficult to get, but it favors. The PECL, that is Principles of European Law, also favor specific performance. So it's not that making specific performance a general remedy is something very different. It is just that we have changed from one system to another system. Now, what is the section after 2018? It says specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14, and section 16. Section 20 of discretion has been done away. So anyone who wants specific performance can ask for it. So what happens when it is a general remedy? The burden lies on the contract breaker to show substitutes are available. Now here I will just take a detour to narrate what happened in the expert committee. The fact whether substitutes are available or not, and if substitutes are available, specific performance should not be granted. This principle is universal across legal systems. And the committee actually recommended that we put a clause in section 14 that specific performance should not be granted where substitutes are available. So instead of saying where compensation is adequate, we said where substitutes are available. This would have brought our law in line with most legal systems. But this part has not been, is not seen in the amendment. Now, when substitutes are available, then it falls on the defendant to show that substitutes are available, rather than the plaintiff showing substitutes are not available. And therefore, this is the outcome of it becoming a general remedy. Balancing of interests of parties is still possible. The promisee can choose the remedy. Actually, I believe that the promisee will choose the remedy in just those very circumstances in which it was available earlier. He is the best judge and he has more information about the transaction, about the market, etc. So he is in a position to take a decision whether he should go into the market and fulfill what he wants privately through another supplier, or should he go after the defendant to get the promise fulfilled. So he knows best. Why should the court or the legal system preempt that choice? The next thing is that he also understands. We were discussing how the promisee can choose, and he must choose wisely. That he also understands his promiser. He understands the defendant. That will the defendant comply if ultimately he will ask for the relief? So he understands that if he thinks that it will be difficult to get performance out of his defendant, then he will not choose it. And thirdly, any promisee will choose specific performance only in those cases where, after waiting for so many years, whether it is trial level or after all the appeals are over, is he willing to wait till that time to get a final order of specific performance? It is just that now the responsibility falls on the promisee to choose. I must request you all to read one article. It is fortunately now freely available by Alan Schwartz. It is called The Case for Specific Performance. And so I would recommend you all to read this article. It's a very good article and quoted in so many articles later. It is also expected that if the view is that parties in India can now be forced to abide by their contracts, it will improve the faith in contracting, and it is perhaps expected that parties also will be more willing to perform rather than say, let the court award damages, then we will see. This is, of course, the perception of most writers uh, who have written articles about specific performance. And therefore, it is hoped that this change will encourage performance. Before proceeding further, again, I come back to the expert committee. The purpose of reference to the expert committee was to increase the ease of doing business. And it is hoped that the amendment which is made will actually achieve that over a period of time. Now, even in those cases where the court considers that specific performance can be granted, and even where now it is now available as a general remedy to anyone who asks for it, and therefore for any promise, technically it is possible to ask for specific performance, there are still concerns of enforcement. Number one is balancing the interests of the parties and the court in terms of costs and in terms of time. And it is believed that specific performance is costlier for administration of the courts rather than compensation. But what is more important is the second point, that it is important that in all cases, the prestige and honor of courts must be maintained at all times. And therefore, a court should be in a position to enforce effectively whatever decree or order it passes. That is in two parts. Number one is it should be able to formulate a decree or order which is capable of obedience, preciseness, and the language is such that the defendant can be compelled to perform. And the second is that whatever the court orders should satisfy the decree holder, because that is the whole purpose of enforcement. So if these factors cannot be brought, then naturally a court should not make that order, should not give specific performance, because that will affect its dignity. It will create an impression among the public that here are court orders which cannot be enforced, and that is not acceptable. The second part of outcome of this is it possible to see that specific performance can be achieved even if the promisor is unwilling? Now, if orders of that type can be passed, then specific performance has been granted. So typically, where the act of the defendant is merely signing, now signatures can be done by a third party, and therefore the order of specific performance can be implemented by executing it via a third party appointed by the court. So that will maintain the dignity even if the promisor is unwilling. However, if the promisor's cooperation is required, then it will be very difficult to enforce the order against the promisor, and that will again create an impression that these orders are unimplementable. And therefore, the possibility of effectively executing the order or effectively enforcing the order is a very important aspect of specific performance. This concern does not arise in the issue of compensation, but it does arise in the question of specific performance. Now, section 14, just let me check. Yes, this is the pre-amendment section 14. And it said that the following contracts cannot be specifically enforced. And the first one said, a contract for the non-performance of which compensation in money is an adequate relief. Now, one might wonder why this is here, but this is here, and I can explain it with the help of one example. If I am constructing a house for someone, I have a contract that I will construct a house on the land of X, and I am not in possession, and I have broken the contract, then X can get it done from somebody because X is in possession. So at that stage, it is better to say no specific performance. If the construction is halfway or I am in possession of that property, then X cannot enter and get it done. So this is a proper case for considering specific performance because X cannot get it done. In the first case, compensation can be adequate. In the second case, it's not possible unless I am dispossessed. And in the third situation, where I have completed the building, then naturally very easy to order specific performance by giving possession back. Possession means handing over the building to X. So it's the same contract, but depending on its stage, the court can decide whether compensation is a better remedy than specific performance. It actually took me a lot of effort to find out the purpose of this clause, but I believe that this is the clause under which the defendant can show that substitutes are available and therefore compensation is adequate and therefore do not grant specific performance. This clause has been removed in 2018. Then the next one is where there are minute or numerous details, and therefore the last part, such that the court cannot enforce specific performance. This means there will be too much cost or burden on the court, because the court will be required time and again to supervise in case the defendant does not carry out his promise properly. So here is a question of balancing these interests. The next one is where it is dependent on personal qualification or volition of parties. So let us suppose that a singer has a contract with a producer that she will sing for the producer for 1 year. She refuses to do that. Let us suppose that she were made to sing. Either she will not sing properly, because when there are differences, people will not be very willing to do so. And even let us suppose she were to sing properly, the producer may not be very happy with what he has received, because their relations are already strained. So wherever personal volition is involved, where the person's own contribution in the performance is required, then specific performance ought not to be granted, because the court will be required time and again to judge the performance of a singer, and courts are not in a position to do that. Then this part, and I highlighted this, is very important, or otherwise from its nature is such that the court cannot enforce specific performance of its material terms. There may be other circumstances, for example, an unlawfulness which arises after the suit is filed. So we all know that unlawfulness which arises after the breach does not matter. But what to do? Then naturally it can't be enforced. Or there is a case of temporary injunction where a court refused to give it simply because this injunction could not be implemented if it was relating to publication of credits in a film. So if this film was exhibited outside the country, then how could the order be implemented, or how could it be enforced outside the country? That was a concern with the court, and therefore the court refused injunction to some extent. This part has been taken away from the 2018 amendment. And where the contract is determinable, or it involves the performance of a continuous duty which a court cannot supervise. So building construction contracts comes here, because if the work does not satisfy the decree holder, then the court will be required again and again either to supervise the construction or to decide again and again whether what is done fulfills the requirement of the contract or not. And therefore, the courts will not order specific performance. There was an exception to this which said that if the contract is for construction of a building, and if its terms are precise and possession is handed over to the defendant, then the court can nevertheless give an order of specific performance. Now, it has so happened that this part relating to construction contracts has not been retained. So we will see later how this works out. So the question of effective enforcement is very, very clearly put out in this phrase in section 14. Its nature is such that the court cannot enforce specific performance of its material terms. And this can happen in these three situations which we just saw. Now, how does section 14 appear after the amendment? This part is, I think, a bad copy-paste job. What we had suggested is, as a committee, that specific performance cannot be enforced where it is shown that substitutes are available. But the amendment has come out like this. I will deal with substituted performance later. The second is where it involves a performance of continuous duty which the court cannot supervise. It remains the same. It depends on personal qualifications of the parties that the court cannot enforce specific performance of its material terms. the word volition has been taken away, and this remains as is. So what is removed, I think, a very important part has been removed by the legislature, and that is this one. It is of such a nature that the court cannot enforce specific performance of its material terms. And this, I think, is very essential for every order or decree of the court. It must satisfy enforcement. And to that extent, this is missing in the current provision. The other thing that is missing in the current provision is one exception given to section 14 relating to building contracts, which I just discussed. So now, building contracts belong to a category that require constant supervision. So under the new provision, it would fall here. And therefore, under the old law, a contract to construct could be specifically enforced. So an order could be passed to the defendant, you construct. Okay. Now, this cannot be done because the exception has been taken away. So on the one hand, we say, yes, of course, a contract to construct, you can always ask for specific performance. No problem. For any contract, you can ask. But this hurdle will not be crossed. So we have to wait and see how this works out. Now, in the first part, I discussed inadequacy and effective enforcement. Despite it being a general remedy, the concern of effective enforcement remain. If you have questions about this part, feel free to ask. Please raise your hand. Where is the hand visible? If you have questions, or put them in chat.
Requesting all the participants, if you have any questions for our speaker, please raise your hands, or you can write your questions in the chat box as well. Thank you.
I think there's one question by Nikita. Nikita, you can please go ahead. You've been permitted to talk.
Hello, ma'am. Good evening. Just wanted to know what are those contracts which are determinable in nature?
Yes. Let me repeat the question, Nikita. Tell me whether it's correct. You want to know which contracts are determinable in nature?
Absolutely.
Yes. Yes. A contract which has a termination clause. It has been applied in court judgments to contracts which are terminable in nature. So it has a termination clause. So let us suppose a contract has a clause which allows either party or one party to terminate by giving, say, 1 year's notice. Now, if a specific performance were granted of that contract, the defendant had the right to terminate anyway. So if the defendant has a right to terminate anyway, then the court should not grant specific performance in those cases. So there are two judgments under that clause. You will find them in any reference book. Okay, we'll come back to questions again at the end of the session, if there are no others just now.
I think we can come back to questions later.
Very well.
We can proceed.
Very well. Right? Very well. Yes. Now, this is a drastic change, and I don't think anybody likes it. What is it? That discretion is taken away. It was, of course, one of the concerns of the expert committee that the manner in which discretion was exercised in various judgments, that led to uncertainty, and therefore discretion must be removed. But the factors based on which the discretion could be exercised, they should remain. I will discuss shortly how the committee recommended that they could remain so that those factors could be considered by courts. So this was the provision before 2018, that the jurisdiction to decree specific performance is discretionary, and the court is not bound to grant such relief merely because it is lawful to do so. But the discretion of the court is not arbitrary, but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. So, it was not a right, even if a plaintiff crossed all the three hurdles of 10, 14, and 16. Getting specific performance was not a matter of rights. This was an occasion where the court could consider, and I'm here, the court could consider circumstances of the case, for example, rise in prices, delay. It could look at the conduct of the parties, of the plaintiff or the defendant, and it could look at their interests and also interests of third parties whose rights might get affected if specific performance is granted. And therefore, we had important principles relating to delay. So although a suit for specific performance can be filed in 3 years from the date of refusal or the date fixed for performance, nevertheless, if the plaintiff took too long to approach a court, so the occasion arose and he came to court after, say, 2 years, although he was within limitation, if he shows that why there was a delay, that can be considered, but otherwise just keeping quiet would take away his claim for specific performance, and especially where third-party rights had intervened. But of great concern was the issue of rise in prices. There are judgments on both sides. There are judgments which say, oh my God, prices have risen, so specific performance ought not to be granted because it will work injustice against the defendant. The other is where rise in prices has been taken into account and the plaintiff is ordered to pay a higher amount to the defendant towards the price. I am talking of immovable property purchase cases because that is what most case law has developed. And the third is where the courts have exercised discretion to grant despite the rise in prices, where they say the rise shouldn't matter. Actually, if the plaintiff had the benefit of the contract at the agreed time, then the plaintiff would have had the benefit of rise in prices as well as the immovable property which he could have used. He is deprived of both the rise in prices as well as the property. Plus, he may be required to pay more than what he had agreed, even after spending so much in litigation. So here was an uncertainty that if specific performance is granted, and in many cases, the case was decided by the Supreme Court almost 30 or 35 years after the contract was made. There's an uncertainty whether a person will get specific relief despite asking. And compensation in such cases is restricted to the time of the breach. So the compensation, if at all claimed and proven, will be such a small amount based on the prices existing at the time of breach, because the principles of compensation are calculated as on the date of breach. So there is this uncertainty. Then the other three factors which were given or cited in section 20 is that the court should use discretion not to grant specific performance if, because of circumstances at the time of making the contract, there would be an unfair advantage to the plaintiff, or there is undue hardship to the defendant from unforeseen circumstances. So we are again going back to the date of making of the contract, or where there are other circumstances which makes it inequitable to enforce. And then there is one more factor, I'm listed here, that the discretion to exercise, to give specific performance ought to be exercised where the plaintiff has done substantial acts towards performance. Otherwise, of course, there is this general principle given in the first paragraph of 20, which says that this is discretionary and it is based on sound principles. Now, the concern is that the courts enjoyed very wide discretion. And while the lower court may exercise discretion, the appellate court may say, no, we do not. So the appellate court may interfere in that discretion and so on. And that leads to an uncertainty. So whether a plaintiff must ask for specific performance, or should he file an appeal, or should he fight it out to the Supreme Court because he wants to get the benefit of the contract, there's a large uncertainty. And this system naturally favors litigants who have the stamina. So they are willing to wait and fight it out to the highest court to which they can approach. And they have deep pockets to be able to do so. So they can, and this is my term, and excuse me for using it, they can participate in this gamble. Let me invest money and let us see, perhaps when I go to a higher court, the court may exercise discretion in a certain way based on the facts at that time. I'm not talking of corruption. I'm only talking of litigation expenses which he is willing to spend. This is the uncertainty. And this uncertainty is a great matter of concern for all of us. We all agree that yes, courts must have the power to intervene in order to undo injustice or unfairness. This is what they are for. I listened to some videos on the YouTube of talks given by retired judges about the amendment. And most of them expressed the concern that taking away this discretion is not a very good thing. Judges will continue to exercise discretion. We have to wait and see how they will do it. And therefore, let me come to what the expert committee recommended. Firstly, that yes, grant specific performance as a routine and refuse only in stated circumstances, which are incorporated in section 14, which says these contracts will not be specifically enforced, and this would cast a burden on the defendant to prove that the circumstances exist for which it should not be given. And these circumstances, if they are indicated, then parties know that specific performance might get refused on these grounds. And the grounds that were recommended were, of course, incorporated from section 20, that substitutes are possible, performance has become impossible or unlawful, there will be unforeseen undue hardship, there will be an unfair advantage, personal volition, continuous duty and constant supervision, undue prejudice to third party. And there was one more important recommendation, that factors after the making of the contract should not affect the grant of specific performance. Now, what has happened? This part of the recommendation has not got incorporated, was not accepted, and has not got incorporated into section 14. And so it seems as if courts cannot intervene to undo if there is an unfairness or injustice. I must also mention that most of these grounds are available as defenses in almost all legal systems in different ways, where specific performance is a general remedy. So the big question is, will courts continue to exercise discretion? And I believe yes. And it is rather now problematic because the factors on which they will exercise are not known. Earlier, a court could refer to the language of section 20 or existing principles laid down from time to time by courts and refer to section 20 for the purposes of exercising discretion, because that was the source of discretion. Will they continue to exercise discretion? Yes, they will, and they should. But now there is even more uncertainty because we do not know the basis on which discretion will be exercised. So this is the second part of my discussion today. If we have questions about this part, we can consider them now. Yes.
Yeah, Dr. Nilima, there is a question in the chat box which I'm going to read it for you. It's
Yes.
from the attendee's name is not given, but the question,
Okay.
little
Yes.
elaborate one. In a contract between a farmer and a company, wherein the farmer is supposed to sell his crop exclusively to the company, and he fails to do so due to vagaries of nature, but the terms of contract didn't provide for such scenario, then would this come under impossibility of contract, or would this qualify for specific performance or compensation as a relief to the company?
Yeah, this is an issue more of substantive law rather than law of remedies. If a manufacturer has agreed to supply cloth made by Victoria Mills, this is from a decided case. If and when supplied by those mills and he is unable to do so, can he claim excuse under Section 56? Or secondly, is it a contract contingent on whether he will get supply from the Victoria Mills or not? And time and again in this and other cases, courts have held that a supplier takes the risk of his supply not being available. And therefore, the question that comes into play is excuse on account of supervening circumstances, unforeseen supervening circumstance, which is failure of the crop. But will it give an excuse? I believe it will not give an excuse. And therefore, it cannot be a question of specific performance, because an order to grow crop cannot be passed, and therefore it will be a good case to ask for compensation. So the company should ask for compensation rather than specific. I hope that answers the question.
Thank you, Dr. Nilima. Anyone else has any questions? You can just raise your hand and we'll unmute you. Thank you.
Actually, Professor Nilima, I would have a question as the panelist itself. I was struck by one particular case where you had a situation where there's a mall and the mall has a shopping center, and there's a contract with the mall that the shopping center would not close, let's say, before a 10-year period. And now the shopping, and now it so happens that this shopping center, or let's say a grocery store, for example, is suffering significant losses in operation. And so wants to shut down, but the contract provides that you cannot shut down before a 10-year period. Now, in comparison to the reliefs, now if the court was, for example, to enforce it specifically, the grocery store would suffer significant losses for 10 years or the remaining period of the contract. However, it would be rather cheap or simple for the shopping mall to get another grocery store for that space. So the loss to the shopping mall is, in comparison, very small, but the loss to the grocery store would be very large if specific performance was ordered. So how do you think that the court would deal with such a situation now that the discretion is not there? And would it also put the plaintiff in a position to, say, strong arm the defendant in such cases, because the defendant faces a huge losses and can maybe would be sort of compelled? So does it go towards limiting the person's personal liberty, and so, or the protection which was there against slavery earlier, and now how would the court deal with it, with such a situation?
A very close facts, a case with very close facts is decided by the House of Lords in 1997. Very interesting case, very similar facts. Basically, an order of specific performance to do business cannot be granted, and it will fall into that category of contracts where enforcement is not possible. Now, an order of injunction that you don't close down means the shop doesn't close down, but yes, you put groceries into that shop and you do business. This part, because it is incapable of enforcement, I believe specific performance cannot be granted. I mean, if I were a judge, and even if there was discretion in the law, even then I would probably decide it under Section 14. But this case makes very interesting. Ultimately, the matter was settled, but the court did decide that we cannot force parties who are in difference with each other. We cannot compel them to work together. This is also something which the court has observed.
Okay, thank you.
Thank you, Abhinandan. Thank you, Dr. Nilima. We have another question from Mrityunjay. Mrityunjay, do you want to unmute yourself and ask the question yourself, or maybe I can read it for you? Okay. So
is it in chat? Yes.
Yeah, so it's in the chat. I
will read it.
Okay, sure.
Yes. In an employment contract, termination clause specifically provides for termination by an employer without assigning any reason by a notice in writing and served by registered post only, email service was excluded. Can an employee challenge a termination notice issued by email and without sending by registered post by filing a suit for specific performance of termination notice served in terms of the employment contract only? I believe the remedy he will ask is injunction to the extent I understand the facts. And yes, and for a declaration that his services have not been terminated because he's entitled to termination by registered post only, right? And this is because that is what the contract allows, or rather enables. So the remedy he can ask for, I believe, is declaration that he continues to be in service, declaratory relief, and of course an injunction that he should not be terminated or he should not be asked to leave. Will such an injunction be granted? If it is a private employee, perhaps no, because that again forces unwilling parties to come together. But specific performance, what is the order of specific performance? What will this employee ask the employer to do? Give me work? Well, will that not be dependent on personal volition of that party? And so on. So I think it will be difficult to get specific performance. This is a good case for declaration, perhaps an injunction, and compensation in the ultimate. And when I say perhaps, you will understand the uncertainty in giving off these remedies. Chinmay Patil, he has a question. In a leave and license agreement, there is a lock-in period clause, and also there is a clause for termination before the lock-in period. It is apparent that the clauses negate each other. So can the licensor ask for specific relief for license fee? So can the licensor ask for specific relief for the license fee? Basically, the licensor has to not ask specific relief, but he asks what I will call, and let me put here, claim in an agreed sum. So he files a suit for the rent, the license fee. And in that, the effect of the two clauses and how they are to be interpreted, that will be for a matter to decide. It is good that you raise this question. There is a distinction between a claim for specific performance versus an agreed sum. So if I have sold goods to you, then I'm entitled to the price. So the claim for the price is agreed. And all I have to show is I have fulfilled the contract and therefore this money is due. If you have not paid me the advance price which you were supposed to pay me and I am willing to sell you the goods, then my claim is for compensation because then I am claiming the loss. Now, if I am not delivering goods to you, then the claim you make against me is for specific performance because you're asking for the promise to be fulfilled. So in an agreed sum, a definite sum is agreed to be paid on the happening of events which are laid down in the contract. So for example, a guarantor says, I will pay if the principal debtor doesn't pay. So the claim of the creditor against the guarantor is a claim in an agreed sum. So amounts under indemnity, amounts under guarantee, amounts in insurance, for price of goods, for loan money which is given, return of loan. These are all payments in agreed sum, and the principles of specific performance do not apply. If you wish to read more about the distinction, a very good discussion you find in Anson's book on the law of contract in the chapter relating to remedies. A question we have, supposing that the court rules to stop the Central Vista project, if not so in reality, then what remedy will be available to the builders with which the government is in contract to build the Central Vista? I believe that it being a contract made for such a large project, the contract itself will provide for remedies and also a very good force majeure clause. So perhaps the remedies will be decided by those clauses. So shall we proceed with the last part?
Yes, please.
Yes.
Please. We'll take the questions afterwards. We have questions in the chat box, but
right.
take it at the end of the
Yes,
session now.
yes.
Thank you.
Now, this is a new remedy given in the Specific Relief Act, compensation on cost of cure basis. Basically, the remedy of substituted performance, the name is given as substituted performance. You find similar provisions in the legal systems in civil law countries, where the plaintiff can ask an order from the court that he should be entitled to get the work done from a third party at the cost of the defendant. I am not aware, because this is basically, I think, German law. I'm not aware exactly how the plaintiff will plead in the plaint, but this is what the law is. He can ask for this order. This is the right which he has. So the right is, I come back to this discussion of what is specific performance. On the one part, it is that the plaintiff should get his work done, the promise fulfilled. And the other part is who should fulfill it. So we leave aside who should fulfill and we say if this plaintiff can get it done from somebody at the cost of the defendant. So this is the part we now come to. Does the Contract Act allow such a claim? The answer is yes. And the Contract Act allows the claim even before the cost is incurred. So I have mentioned illustrations F, K, and L of Section 73 of the Contract Act, which provide for compensation on what is usually called the cost of cure basis. So there is a construction done and it is defective. So the entire cost of repairs can be recovered from the contractor. There's a building done in an unworkmanlike manner. So get it done from somebody. The owner of the building is required to get it done from somebody else. The cost of getting it done, he can recover. So what is the problem? Why do we need a new remedy? And there is one more thing of the Indian Contract Act, that the amount can be quantified and claimed even before the work is done. Because, and the answer is very simple, because this person who wishes to get the work done may not have the money to get it done at all. So he can simply say it's going to cost me so much, so give me the money. Let me take a very beautiful example from an English case, and I take it just as an example, not the decision part, where a person wanted to have a swimming pool constructed of, let me say, 7 feet 9 inches. Now, the regulations required that the swimming pool could be 7 feet. So he had those 9 inches, which was his personal choice. The contractor constructed the swimming pool of 7 feet, which fulfilled the regulation, but which was not according to contract. Now, this owner of the premises, he claimed a large amount equivalent to the cost of redoing the swimming pool, digging it back to 9 inches more, and reconstructing it, which was a very high amount. And he was entitled to claim it on the basis of calculation. So the question before the court was, is he entitled to claim it? The answer is yes. Can he claim it without actually incurring the expense? The answer is yes. But should it be granted? And of course, in that case, the court considered that if this amount was given to the person, he will simply keep the amount because the swimming pool is good enough for him and that will be a lottery for him. So the court adopted another method of calculating compensation. We are not on that part. We are on this. I'm just highlighting this case to tell that yes, the claim can be made even before the amount is actually spent. And this is given or allowed under the principles of compensation. And this principle still remains despite this amendment. Then Order 21, Rule 32 of the CPC provides that when an order of specific performance is granted and it has been disobeyed, so at the stage of execution it is disobeyed, then the court can order that promise to be done by a third party, and the cost of that will be recovered from the judgment debtor, that is the defendant usually in a case for specific performance. So the work can be got done from somebody else in a suit for specific performance, but at the stage of execution proceed. So what has the amendment done? The amendment has, and there is actually one more I should add here. Many contracts provide for risk and cost clauses. Means the contract itself says that if the contractor does not do the work or fails to carry out the work, the employer will get it done through a third party, and for all that expenses, they will be recoverable from the contractor. So when all these are there, what is the need for this new remedy? This is the question. First of all, Section 20. Let me talk about 20. We recommended that the section should be called 20A simply because Section 20 as it existed, that is discretion, is still to be applied in pending cases which are pending in courts. Appropriately, this section should have been 20A, but that is not the case. So Section 20 as amended gives to the plaintiff an option to claim on the basis of substituted performance. So what does he do? When the other party has not performed the contract or has broken it, he should issue a notice in writing to that party, giving him 30 days, a 30 days notice, in which he should say, calling upon that other party, perform so and so promise within this time. So he gives a time, and I believe this time should be a reasonable time because that word is not used in the section. So the time should be given that you complete this promise within the time, and this notice is given for 30 days, within 30 days. And then there is a refusal or failure by that other party. Then he can perform it himself or through a third party. And whatever are the costs and expenses after getting the work done, he can claim them after getting the work done. Whatever are the costs and expenses. Now, what is the difference? The difference is that under Section 73, the court still had the control over contemplation and mitigation. Here, whatever cost he has incurred and expenses he has incurred, it is expected that the court will order these to be given to him. We all can foresee that any party can create problems in the implementation of this routine. When the work is got done, extra work can be got done. So, has really the same work been got done by the plaintiff will always remain for the court to decide. The other part of this section is that it does not bar the remedy of compensation. It means that a claim can still be made just under 73, especially even before incurring the cost. And despite getting the work done by way of substituted performance, even then, because of the delay, there might be losses. So these losses also can be claimed despite claiming amount under the remedy of substituted performance. The main purpose of adding this section is not that the claims should be fulfilled. The main purpose is that if this remedy is available to the plaintiff, then perhaps both the parties will come together and renegotiate the terms of their contract on more favorable terms. If that happens, then that is the success of this provision. And we hope that this provision will be used and utilized. If there are risk and cost clauses, then naturally the risk and cost clause will govern how the calculations are to be made and which expenses can be incurred and what procedures are laid down. But if there is no such clause, then a similar right is available under Section 20 to under any other contract. So, what is the effect of amendments? These amendments. If a person can be compelled to specifically perform, that fulfills the principle of pacta sunt servanda. It also fulfills the expectations of the parties. It is very difficult to tell a client that no, you cannot claim performance, you will have to ask for compensation. It's difficult to convince. But now specific performance is available. It is hoped that these amendments will change contract behavior. It is hoped that they will increase confidence in making contracts. And it is also hoped that it will remove uncertainty of enforcement and therefore increase the faith in contracting. Will it affect litigation? Will it increase filing? I do not think so, because ultimately the promisee has to make a wise choice of whether he wishes to claim specific performance or compensation. And this remedy of substituted performance, it is hoped, will encourage negotiation and settlement. So I had these points to discuss. There are other amendments which are proposed. One is relating to injunctions, that no injunction shall be granted which would impede or delay the progress of infrastructure projects. And there is amendment relating to appointment of experts in proceedings. So this is all I had to discuss with you. If you have questions, I will attempt to answer.
Dr. Nilima, there are a few questions in the chat box.
Yes, I think we covered Chinmay Patil's question. So now I come to Kirti Gadkari's question.
Okay.
What could be an exception to the presumption of inadequacy in a case specific performance of immovable property? Question relating to the first part, that's all right. A suit is filed for specific performance of a contract to sell land, and the person is purchasing it not for his personal use, but he is purchasing it because he deals in land transactions. So if it is shown to the court that his purpose is not for personal use, then naturally compensation will be adequate. This is based on a decided case. You will find it in reference. Nikita Thapar. Post-amendment, can a party claim for compensation in addition to claiming specific performance? In what situation this concurrent remedy can be availed? Post-amendment, the section relating to compensation, which is section 21, remains the same. But there is one small amendment, and it says that, the earlier section said that compensation can be claimed in addition to or in substitution of specific performance. I do not know why. I mean, the committee didn't recommend. But the current act now removes the word in substitution of. And the only words which remain there is compensation can be claimed in addition to specific performance. So yes, a party can claim compensation in addition to specific performance. The person, I will give you an example of this. And I repeat, my examples are relating to immovable property because most cases have been decided relating to immovable property. Suppose I have agreed to sell you a plot of a house, and I have not sold it to you. You have gone to court, you have asked for specific performance, and you get it at the end of 25 years. During these 25 years, you are probably staying in rented premises, plus you were deprived of a place to stay. This is your loss. So even if you get specific performance at the end of 25 years, your loss still remains. This is the loss that you claim in addition to specific performance, an example of such a loss. But now that you have raised this point, this new question that arises is that will the court grant compensation in substitution of specific performance? Because these words have been removed. Let me take an example. That there can be circumstances after the making of the contract. For example, a law comes under which now the property cannot be sold. This is not an excuse. Compensation can still be awarded because the breach has occurred before this became unlawful. So, in the earlier situation, because the court could not grant specific performance, there coming a law in between, like the Zamindari Abolition Act. The court then considered granting compensation because compensation could be granted in substitution of specific performance. Well, apparently this cannot be done. Let us suppose a person asks for specific performance and for compensation. Can he ask for compensation at all? One view is that this word substitution is taken away, so how can he ask? The other view is that alternative reliefs can anyway be asked under the CPC. And the earlier restriction that you couldn't ask in the alternative because it showed that compensation is adequate, right? And therefore you're not entitled to specific performance. This fear no longer exists. So alternative relief can always be asked. But the question is, how do you deal with removing these words in substitution of from subsection 1 of 21? We have to wait and see how things develop.
Dr. Nilima, there are a few questions in the Q&A
The question
box.
and answer, yeah.
Yes.
In the case you told a swimming pool was required to be built in size exceeding the authorized size, the court granted relief for the swimming pool didn't satisfy the personal choice of the party. Suppose there was some penalty which such party would have to pay for having a swimming pool bigger than the authorized size, would the amount of penalty be deducted from the amount of compensation so awarded? When you say penalty, I believe penalty because it is more than authorized size imposed by a third party, like, for example, the planning authority, if that is the meaning of penalty. I would say that compensation is always calculated on a net loss basis. So the gains are also to be deducted from the loss, and any such penalty perhaps would also be deducted. In this particular case, the issue of it being unauthorized did not arise. So it fulfilled the regulations, and therefore this question didn't arise. There's another question. Contract is usually rigid in its terms. Any change in the terms amount to novation, provided that the original contract has been breached. Wouldn't the grant of specific or substituted performance be a new contract? When we talk of novation, we are considering change of terms made by both parties. Now, if it were not for the remedy, the same claim could still be maintained under Section 73. It is just that the remedy has increased the chance of getting the whole amount of expenses which have been covered. So it won't be a new contract, even if the contract is breached.
I think we are done with the questions. Any other questions? It's a final call.
So thank you very much. It was wonderful to be with you all. Yes.
Thank you so much. I think that's the most informative webinar. And from aspects to specific performance to exceptional nature of remedy, effect of inadequacy, there's concerns of enforcement, substituted performance. This was the most enriching session, I would say, and I have taken notes. I'm sure you all have taken notes from today's session. Thanks again, Dr. Nilima. It was a pleasure having you here with us today. Also, thank you so much for your session. And also we have with us today, Director EBC Learning, Mr. Abhinandan Malik. A passionate academician himself, he wears many hats within our organization. His mantra is simple: fall in love with the law and the law in the legal education. Good education gets you results, whether in your law school or later in life. Let's hear more from him about EBC Learning and how we can maximize our learning with his online law portal. Over to you, Abhinandan. Thank you.
Thank you so much. Thank you, Professor Nilima, for such an engaging session. There's much that I have learned, even though I have been, I don't know if you're aware, but I've been authoring a few courses on EBC Learning itself on contract law. So this is an area that was particularly of interest to me as well. And thank you very much for such an engaging webinar. Thank you all participants. Before we sign off, I just wanted to, for anybody who's interested, I would like to just run through the EBC Learning platform for 5 minutes and just show you what is there and then answer any questions that you may have regarding the platform and the kind of courses, etc., that we do offer. So let me start by just sharing the platform with you. So yeah, this is the EBC Learning platform that is at ebclearning.com. And what we provide here currently are a library of courses. So if you go to the view all section here, you will enter into the browse courses section. Here itself, so what you do get as part of EBC Learning is that once you do subscribe, you have access to all these courses. A lot of these courses are, of course, skill-based courses where you have things like contract drafting, or say even for a law student, practical skills for going into practice and how you should, even things like dress and talk to people or make connections with people. And of course, now what is new on EBC Learning are the law school courses that we are trying to offer. So for example, you have now, like I just mentioned, my own course on contract law, then there's on company law, there's a course on legal research and writing, and so even arbitration and others. So these are all very rigorous courses that we are providing for law school education. And These courses, of course, they're not only useful for law students, these are also useful for practitioners who may want to brush up on any particular area of law. For law students, again, who've pursued their course, later on also you may realize that there are certain gaps in your education where perhaps the course at the time that it was being conducted in your law school, maybe you were not available, you were perhaps mooting, or there was some other activity, or maybe the faculty there sometimes may not be that good. So you may want to brush up on those courses. So here is the opportunity that you can go to EBC Learning and access these courses and go over them. Again, now, why are we providing these courses? Our objective on EBC Learning is basically to help you fill those gaps that may have occurred in your education for whatever reason. And we believe that these gaps or these foundational courses are your basis on which you then build your skill-based education. So before you go in for skill-based education, for example, before you go in for, say, the contract drafting course, you may want to study contract law itself and go into that, brush up your entire basics, and then go on to things like drafting, etc., which will give you a clearer understanding. So although there's a lot of talk about skills today, we believe that it is very important for you to have a solid grounding in your foundational law subjects at whatever time in your career you may find suitable to watch them. So thank you again for being with us. Thank you for attending. If anybody has any questions right now regarding the EBC Learning platform, I would be happy to answer them as well. Well, in case you do have any further questions, you can, of course, write to any one of us or email me, and we'll be happy to get back to you. Thank you everyone. Thank you, Professor Nilima. Thank you, Dr. Aanchal. Thank you, everyone.
So I'll just say a final thank you, Abhinandan, for giving our participants the glimpse of EBC Learning. I'm sure our audience can make full utilization and can experience a lot at our portal. Do watch out for more interesting webinars from our learning portal, and we have been doing a series of them with some great and eminent speakers. And it is available on YouTube as well. Our next webinar is on intellectual property rights, next Wednesday, 6 p.m. So do join us again. And if you have not subscribed to EBC Learning, I would say do it now. Build and strengthen your legal education with us. EBC Learning is just a click away. So that's all for today, everyone. Hope you all had a great learning experience. Have a lovely evening and a great weekend ahead. Thank you. Thank you from TBC.
Thank you, everyone. Bye-bye. Good evening.
You.